formal introduction, Josh Wright is professor and executive director of the Global Antitrust Institute at Scalia Law School at George Mason, and a former FTC commissioner himself, I might add. And Ashley Baker is the director of public policy at Committee for Justice. And I guess I should say I'm of course the William Hild executive director of Consumers Research, who's hosting this event. So thank you all for joining us. And to get it kicked off, we're really going to talk about two subjects today and how they interlink: the DOJ case and the House report that came out on antitrust. But to get us started off, Josh, why don't you tell us a little bit about the DOJ case and sort of what motivated it, what are some of the pros and cons, and what you think about its likelihood of success?
Sure. So why don't I, and first, thanks for having me. It's fun to be here. And, antitrust is a big deal. So there's good, fun stuff to talk about. And it's, I've been roaming around antitrust when it was a desert without much going on. And it's, now it's more like drinking from a fire hose. So, so the suit, why don't I start with a general description of what's in it? And then I'll sort of give you a couple of my thoughts about the claims, what's in it, what's missing from it, to sort of tee up for discussion. So a couple of things. So the suit is it's a Section 2 Sherman Act monopolization suit. And it is really what I would describe as a relatively narrow monopolization claim under Section 2 of the Sherman Act. What I mean by that is the suit alleges that it's what we call a monopoly maintenance claim. So it is not a claim that Google took monopoly power in search and used it to create monopoly power in other markets. And it's not a suit that challenges how Google achieved monopoly power in the search market. It is a claim that it has used its market power in the search market to harm competition in that market and in some search advertising markets. Monopoly maintenance claims, it's sort of, the complaint is drawn up, I think, best it can to walk and talk like the DOJ Section 2 claims in its Microsoft case at the turn of the century. I'll talk a little bit about differences in those claims for people who are similarities and differences for people who are less familiar with it. But the claim really is about two things, and they're similar. They're search distribution agreements that Google enters into. So the suit challenges, you take the Apple agreements as sort of one bucket of these claims. And so Google has revenue sharing agreements with Apple to be the default search device on iPhones. And those agreements have been in place for a couple of years. And Google pays a lot of money, $8 to $12 billion or something like that is the size of the fee. It's a good chunk of Apple's revenue, and there's sort of big size payments to be the default. What the agreements don't do is they don't prevent Apple from having other search engines on the phone. They don't prevent them from, they can choose to have another default when the agreements expire. You can have sort of as many apps on the phone that go to other search engines as you like. But that's sort of the battle over how important it is to be the search default, and what under the antitrust laws you are allowed, what methods you are allowed to take to become the default is sort of a big fact issue in the case. So if you go back to Microsoft at the turn of the century, the exclusive dealing portion of the case was Google entered into a bunch of agreements with AOL and other internet access providers that said, hey, AOL, when people dial in to get their internet access, you use exclusively the Internet Explorer browser. They had some exceptions where you could use Netscape if you begged hard enough or what have you. So they weren't really exclusive dealing. But users had to go through a bunch of stuff to get outside of the Internet Explorer experience. A big difference here is that for users, you guys all have phones and there's lots of different ways to get to different search engines. It is not a difficult thing to do to switch to another search engine, or just even to change the defaults. Whether that difference carries the day in the case, we'll sort of see, but you're going to see a lot of fight over how important it is to be the default, about the competition to be the default, right? So why are they paying $12 billion? Google's going to come in and Google's going to say, look, some people are going to use, our Google search no matter what. Some people want to use DuckDuckGo or Bing or whatever, no matter what. But lots of people, like, you walk into the supermarket and whatever's at the eye level shelf space you grab. You may know you like Coke, you may know you like Pepsi, but it's the people in between who grab the eye level shelf space. And those are really valuable sales, just like they're really valuable searches for the people sort of indifferent and eat whatever's in the default. And I think the factual battle on the search default is going to be, is anybody foreclosed from setting the defaults? And if so, do we care? Is it that people don't switch from Google when in the default because the search engine's better? That's not going to violate the antitrust laws. You're allowed to win the competition for distribution. What you're not allowed to do is set the rules so that the other search engines can't compete for distribution. The other bucket in the case is similar, and that is agreements in the Android ecosystem that set defaults, right? So you can get Android for free, but if you sort of take the Google suite of apps with it, there are a bunch of restrictions on what you can and cannot do. What you can do is put on other search apps. What you can't do is sort of take them off, right? And so you'll have both in the Android ecosystem and sort of with OEMs, you'll get battles over search distribution. Both of them, and effects on competition in that sort of search default space on rival search engines. That's kind of where the rubber hits the road in the case. How important is competition to be the default? Is that a competition that the antitrust laws sort of celebrate or shun? Can you win those competitions by being the better search engine? Can Google explain to an Article 3 judge why those agreements exist? And distinguishing from Microsoft and other exclusive dealing style cases where users are locked in, sort of as a factual matter, the DOJ will come in and say, but in real life, nobody switches. And Google will say, yes, that's because we're better, but they could switch if they wanted. And that's going to be the fact question I think drives the outcome in the litigation. I remain, I'll say, for just sort of my last thing, I remain skeptical that this claim prevails, in large part because what courts often do in exclusive dealing oriented cases, and notice there's no exclusive provision in these contracts, this is just sort of competing for the shelf space. They define foreclosure, the thing you need to show to prevail in these sorts of cases, requires something more than just winning the shelf space. You're allowed to compete to win the shelf space. And I'm not sure, and I don't see much in the complaint yet, and it's early, that suggests to me that they will overcome that hurdle. The very, very last thing is what's not in the case. The states are out there. There can be other claims that aren't part of this. I would say, I started off by saying it's a relatively narrow claim. It's not particularly novel. It's meant to walk and talk and sort of look like Microsoft, and it does. And so it'll be a battle over the facts. But there's lots of other potential claims floating out there. I think we have not seen the last Google case. Certainly the feds will get involved at some point. There's been lots of talk about Dem state AGs bringing a broader case that gets into the advertising side and gets into some of the other issues. So that shoe, I think, will likely drop sometime in the next couple of months. I don't know. I stop there.
Yeah, certainly. Well, I have a ton of questions for you, and we will get to those. But first, I want to have Ashley, give her a chance. She's going to talk to us about, and as it relates, obviously DOJ is one specific case of more interest in antitrust enforcement and law, but another is the House recently put out a very large report, very major report on antitrust and what reforms might be needed, both in terms of statutory language changes and as far as capacity for enforcement at the agency. So Ashley, why don't you sort of give us a good briefing on what that report said?
Sure. Thank you, Will, and thank you for having me. So earlier this month, and this was about 2 or so weeks before the DOJ case dropped, the House Committee on the Judiciary released a report on the state of competition in the digital marketplace. That this report was the result of around a 16-month-long or so investigation. And I'll just describe the report as it describes itself, which is an attack on how America has approached antitrust for the past 40 years. So it kind of comes out and says it there. And I'm not trying to underscore how much work went into this or the importance. It's a pretty ambitious report. It's around 450 pages long or so, and it's not targeted towards any specific problem though. Did we lose Will? I think he's still here. We're still both connected, right?
I still have you. I say, and it looks like the participants are here. So I say, keep going, Ashley.
Okay, we'll keep going. Okay, so anyway, it's around like 450 pages long, and it just really proposes. I'm frozen there, am I not?
Yeah, I apologize. I think it was on my end. My whole browser.
That's
stopped.
a really flattering face I'm making there.
Well, I can hear you, Ashley, if you want to keep going.
So I'm going to keep going. You can hear me though, right?
I can hear you. Yep, please continue.
Okay. So anyway, it's like I said, it throws out a lot of recommendations. It also spends around more than about 375 pages complaining about big tech, and there are a lot of anecdotes there that rely on like hypothetical harms really to competitors. However, the report does have a lot of implications that goes far beyond big tech because of the sheer broadness and the number of recommendations in it. So I think it'd be kind of a mistake to ignore any of these recommendations, especially with the potential of Democrats taking both chambers of Congress. And regardless of whether or not they do, the recommendations still have a lot of political momentum. Although the report came from the left side of the aisle, many of the arguments are coming from the right side right now as well. That said, I should probably say a little bit
Well, apologies, audience. Things we were Zoom. I think this might be on Zoom's end because we're losing each of us in succession, and I'm not really sure what's creating the issue. Josh, do we still have you by any chance?
I'm still here.
Okay, great. Well, I assume Ashley's going to try and join back in. So until she does, why don't I follow up on some of my questions around the DOJ Google case. First of all, let me ask the broad question. Well, in either case, whether the DOJ prevails or the Google prevails, do you see a significant difference as far as its effect on consumers? What are some of the outcomes that might change the user experience for the average consumer?
So it's interesting, and your question raises the issue of the remedies available for the potential suit. There's a couple of interesting things about the way the DOJ suit is crafted that I think are worth talking about here. So again, the suit is relatively narrow, and it is about these couple of agreements with Apple and then sort of the Android distribution agreements to do with search defaults on Android phones and iPhones. And so let's say the DOJ wins. I think I've said I'm happy to bet the other direction right now. But let's say they win. What remedies, what could we expect to change? This is not a case where you're going to see structural relief, right? There's nothing in the claim. The claim is that these contracts are bad. And so if they win.
So in other words, because you likened it to the browser wars that led to the Microsoft enforcement action, but there, I think the DOJ was actually asking for Microsoft to be splintered, whereas that's not what's being asked here, to be clear, right?
They've, they're general about the relief they're asking for in the complaint, and they could ask for it later. But the difference in Microsoft was it wasn't. So Microsoft, the allegations were a bundle of different things. There was some exclusive dealing in there that looks like this, but there was also allegations that Microsoft had commingled the code of the browser of Internet Explorer and the operating system. There were tying claims. And so the argument was, look, to correct that commingling, you got to break them up, right? That's the remedy for the claim. We don't have that here, right? You just have the contract part, right? And so I would be hard pressed to believe that any Article 3 judge would be persuaded that the way that you handle a handful of contracts about search distribution is by breaking up a company. It's just not the remedy that fixes the problem if you have a problem. So what kind of remedy would be on the table if you won? Well, there are lots of exclusive dealing type cases where we can look to see what kind of relief you're talking about. The most obvious one is an injunction that says, hey, don't enter those contracts. And that sort of tends to be what you see in these sorts of cases. What makes that interesting is, so Google is competing with others for that search, sort of prominent placement in the Apple ecosystem, let's say. And those payments are, Apple's happy to get them. Apple is subsidizing its own entry into the search engine market, right? It's making phones cheaper on the Android side. So what do you tell Apple? I mean, Apple has an auction, more or less. Apple stands up and says, hey, Google and Bing compete to be the default here, right? And you have a court say, okay, Apple, you can have that auction, but what? Google can't participate in it, or they can participate, but it can't be exclusive, or something, right? I think those are the types of remedies you'll see on the table. It's hard to imagine a competition case in which a judge says the way we fix this is by not allowing Google to compete for distributions. I don't think that's likely, but that's what you're going to see. You're going to see some tinkering with the way that competition for the default space takes place.
Do you think this case? I mean, you mentioned there's a state level, I think, movement in all 50 states now, is my understanding, against Google, and a number of AGs have expressed, on I think both sides of the political spectrum, have expressed interest in pushing back against their market position. Do you think that this is something where if they this may only be the tip of the iceberg? In other words, what's significant more about this case isn't so much the material that they're going after. It signals a broader interest in going after Google specifically, or big tech in general.
That's good. It's a good question. There will be other cases. I think there will be other cases, whether there's an administration change and we see a Biden administration, DOJ, bring more broader claims, or whether that's left to the states. I think you've got a lot of state interest on the advertising side to bring some other types of claims. So I do think you're going to see more. Exactly what, I think, is hard to predict, but I do think you're going to see more. And frankly, I think if I were someone who thought that actually started talking about the environment that generated the House report, and the premise being that the antitrust laws are all broken, and here's a bunch of proposals to deal with it. If that were my worldview, and it is not, but if that were my worldview, I would look at this case, this particular claim, and be a little bit, what's the right word? Disappointed, maybe, in the sense that if you're someone who thinks that if you're someone on the right or left that thinks that the answer here is breaking up companies, that ain't what this complaint is.
Got it. So it's sort of if this is an opening volley, it's sort of a pathetic, not pathetic, maybe that's too strong of a word. It's underwhelming, shall we say, if you're of that view that you need some really robust enforcement in this area. I think we have Ashley back with us. Ashley, you on the line again?
Yes, I'm so sorry about that. That's embarrassing. I've done like over 20 of these in the past 2.5 weeks or so. I've never had a technical problem, but Windows decided to like.
Well, no worries, because right before yours crashed, mine did. And I don't know about you, but I'm using a Google browser, so maybe we should blame the subject of today's discussion. Maybe they're listening in.
Yeah. I'm sorry if I'm looking this way and that way. I'm hooked up to a different monitor. Now, where did I leave off? Because I did just spend about 10 minutes, I think, talking to no one, maybe. Where did I leave off with the?
Unfortunately, I broke out right as you started. So why don't you take it from the top?
Yeah, sure. So to start over again, and I'm sorry if I'm repeating anything here. Sorry for messing that up. But so a couple of weeks before the DOJ suit was dropped, the House Committee on the Judiciary released this report about the state of competition in the digital marketplace, and it was the result of a 16-month-long investigation or so. And I'm going to describe the report as it described itself, which was an attack on how America has approached antitrust for the past 40 years, which I think is pretty accurate. And it's a really ambitious report. I will say that, and it's about more than 450 pages long, and it's not really targeted towards any very specific problem. It's not very narrow. It's really just all over the place. And it throws out dozens of recommendations to Congress, I think, just kind of to see what sticks. We're still here, right? Okay, I am just making sure that I'm not talking to no one again. So, however, it does have a lot of implications far beyond big tech, just because of the broadness of the recommendations. It does spend about 375 or so of those pages just complaining about big tech and giving a lot of anecdotes that rely on hypothetical harms to competitors that we don't know if they would exist or not. Which is, from a legal perspective, a very problematic thing. But still, I think it'd be a mistake to ignore any of the recommendations that are in the report, or to not focus on this anymore now that there's more antitrust action going on. I think we need to not forget about the report, because especially with the possibility of Democrats taking both chambers of Congress, we could see some of this potentially enacted. And regardless of whether they do, the recommendations do at least have a lot of political momentum. Although the report ultimately came from the left side of the aisle, the arguments are coming from the right as well. That said, I should probably say a little bit about the process itself. So Chairman Cicilline had built up a lot of anticipation around the report for the past couple of months, said that it would be released soon, and then promised it would be bipartisan, did that over and over a couple of times, and then ultimately it was not a bipartisan report, and no one from the minority signed on at all. There was the third way report, is what it was called, that was authored by Representative Ken Buck and had 3 other members of the minority on it, but ultimately there were no signatures from the majority. So this was really a very partisan report at the end of the day. And some of the recommendations, I think, are pretty partisan as well. So like I said, the report's all over the place. And some of the things that it calls for, just to list a few, because I can't possibly list all of them, within a couple of minutes, but to list a few, it calls for new regulatory agencies, for inverting the burden of proof and shifting it away from the plaintiff. It calls for overturning more than 20 Supreme Court precedents, which is pretty much all there is, I think. And that's pretty drastic. And not courts, but Congress overriding those. And many of these decisions, by the way, were unanimous or nearly unanimous. It also essentially outlaws mergers and acquisitions by companies with more than a 30% market share. It also then strangely recommends that clarifying that market definition is not even needed for proving antitrust violations. So I suppose hypothetically any company could have a 30% market share, right? It also proposes extending the Sherman Act to prohibit abuses of dominance. I don't really know what that means. It could really mean anything. And even kind of in a footnote, it calls on Congress that the views set out by Frank Easterbrook should be clarified in the limits of antitrust. They do not reflect the views of Congress in enacting antitrust laws, which is pretty crazy. I guess those who write law reviews articles aren't even safe from the House Judiciary Committee anymore. It calls on possible breakups and other structural remedies that are not only pretty drastic, but on a more fundamental level, they just don't really make any sense. For consumers, though, the value ultimately in the platform is the platform itself. And just in case like all of these recommendations for public enforcement aren't enough, the subcommittee also recommends lowering the pleading requirements, abolishing standing requirements, and banning arbitration agreements in order to create a clearer path for class action lawsuits. And that, by the way, does not apply to just the tech industry. And you know, for those that follow, banning arbitration agreements is kind of a pet issue for many Democrats as well. If I had to bet, you know, that was one of the many things that kept all the Republicans off of the report. Many things though. But I think overall, like looking at the report, it's important to ask, like, what are we asking that antitrust enforcers achieve? And also, is it reviewable in court? And a lot of the problems in the report in the current antitrust debate more broadly they're not competition problems. And overall, I would say this report seeks to shift away from the consumer welfare standard, which is kind of a broader overview that we're going to talk about today, and towards more bright line rules and towards more of a public interest standard. And under the consumer welfare standard, companies' action has to harm both competition and consumers, and that's really significant that we're moving away also from something that has made sense for 40 years. It's given us reliable outcomes. It's based on empirical evidence. It's worked for a long time. I think a lot of people need to kind of go back and look at the history of antitrust and how far we've come to get here, because it was certainly quite unreliable in outcomes beforehand.
Certainly. Well, let me dive into that a little bit, because I think it's important for the audience. We kind of lay out a little bit of the history of antitrust and how it got here. Is my understanding, Ashley, is that you have a constellation of antitrust litigation back when monopolies were called trusts, which is where we get the word antitrust, and like the Sherman Act, for example, and there's a few others. And this is a very telescoped history, and please fill in as you see fit. Then that led to robust enforcement actions in a number of different industries that broke apart a number of different companies. And then that became sort of the modus operandi for a number of years until the 60s and the 70s. You had a situation in which the guiding statutes were broad enough that companies, generally speaking, didn't have a lot of clarity as to when their M&A, their mergers and acquisitions, would lead to an enforcement action, or what types of behavior were anti-competitive, or could be, obviously there were some very obvious things, but there were also a number of things that you and I would probably, or the broader consumer market would probably find very pedestrian, that were considered out of bounds at that time. And more importantly, a lot of companies didn't have a lot of understanding of what the rules were ahead of time. They would basically wait to find out until they got a knock at the door from the FTC or the DOJ that they had done something wrong. And then in the 1980s and 90s, we had the development of the consumer welfare standard, which is sort of the law of the day. This was developed through court jurisprudence.
Seriously? Have we lost him too?
I think we did.
There we go again.
There he is.
Google must really not like this. We're getting too close. Apologize. Where did I leave off?
You left off right before you were getting to the development of the consumer welfare standard.
Got it. And I think, as you noted, Ashley, the consumer welfare standard required that there both be harm to competition and the consumer. So it wasn't just about what you were doing to other companies in the industry. Ultimately, the focus was on what you were doing to the consumer. And obviously, as a consumer protection organization, we think that's very important. And so that has sort of, that jurisprudence and that doctrine has sort of ruled antitrust up until bringing us up to present day. And now we find that being questioned for a number of different reasons. I think both, this is me speaking personally, some that I think are legitimate and some maybe less so. Do I have that? Obviously, that's a very telescoped history of the state of the law, but I thought that would be important as we get into a discussion, sort of where we came from, why the consumer welfare standard was developed, and what it has allowed us to do. Is that, how would you, add or critique to that?
I think overall it's pretty accurate. I think you're kind of understating to an extent the extent to which pretty much everything was illegal prior to the consumer welfare standard. You know, the law is very broad and pretty much everything was legal. I know there was a Supreme Court case which Justice Potter Stewart, she said, the only thing that's clear in antitrust litigation is that the government always wins. So that was usually the outcome of any of these cases as well. So yes, it definitely, the consumer welfare has kind of become the lodestar of antitrust, has given us something to go by for the past 40 years. Absolutely.
Got it. Well, good. With that lay of the land, maybe we can dive into some of the issues I think that are definitely being discussed outside of this judiciary report or House report, which is why they felt the need to dive into it, and then get into how they describe it, maybe some of the remedies that they suggest, and what your opinion would be on the wisdom of that. And please, Josh, join this discussion. I think obviously your views would be very valuable in this space. If it's all right with you, Ashley, I'd like to just talk about some of the things, because I think a lot of antitrust discussion doesn't start until you've got some sort of either proposed, nightmare scenario or an actual nightmare scenario, some sort of abuse or alleged abuse by a company. And then, we try to figure out how we can prevent that in the future. And that's sort of what generates the conversation. I think it's important to start with some of the examples that people are throwing out there. One of the things that the report found was that some of the bigger tech companies like Google and Facebook were using acquisitions basically to dominate any potential upstarts. Anyone that would in theory could grow to be in competition with them, they would just do a buyout offer that they couldn't refuse. What would you say to those allegations, or what does that do to the market, or is this something we should care about or not?
I mean, first I would say that those allegations aren't entirely accurate. Kind of looking at it, I mean, not only just the data that they use, but looking at the startup ecosystem as a whole. If you really break down the numbers, by the way, they're looking at the number of M&As in the industry over a period of like 1998 or so until now, at least. And then you break it down by the number, and it's the number of companies in the report. If you break it down by that number, it's like 5 or 6 acquisitions or mergers per year. It actually doesn't really come out to that many, especially given how many startups we have here in the United States. I'd also say that most of these, it's not like they're gobbling up these companies just to get everything that they possibly can. Most of them do. A lot of startups do. Their ultimate goal is to be acquired. And those who do have potential to survive the market on their own as a completely new novel platform or product or whatever, they usually steer clear from that path of going down the acquisition sort of route. So I think that kind of also there's a bigger problem too, in that a lot of these proposals would really cut down on the amount of venture capital invested, and there's good data on that too, and there's a lot of literature on that, and the effect that it would have on some of these proposals would have on the startup ecosystem in the United States. So I think that's one other thing to note. I'd like to see if Josh has anything to add to that though.
Sure. So it's an interesting area, and there's starting to be a lot of research into the idea of the killer acquisition, right? So there's a great paper by Florian Ederer, who's an economist at Yale, that looks at pharma, right? And so it's identification of sort of buying drugs in the pipeline and burying them, right? And it's sort of been an extrapolation of those ideas to mergers that might diminish potential competition. So I buy somebody who's not competing against me today, but might be tomorrow, right? And this has always been a struggle in antitrust, because we have, a supermarket merger, a coffee shop mergers. I've got data to deal with because I've got a market that's happening today. And I can, as an economist with my economist hat on, I can estimate demand elasticities, and I've got models, and I can predict price outcomes. But if the theory of harm in the case is, there's a guy in his garage who might compete against me tomorrow and I buy him out, there's the policy trade-offs that Ashley mentioned. Well, that guy is in his garage partly because he wants Google, Amazon, Facebook, whomever to buy him, right? And so there's not wanting to dampen the incentives for the innovation that happens for the small guy. We don't there's an old George Stigler had said, barriers to entry and barriers to exit are the same thing, right? You got to let that guy exit. And they want to, Now, it doesn't mean that the antitrust rules should allow anti-competitive acquisitions. I think the interesting thing for the policy debate here is whether, so sort of two different questions. There's one, has there been a demonstration that there are a bunch of these mergers that are in sort of innovation pipelines that are generating competitive harm? I think the answer to that is not yet. I don't think that's been shown. There's not, right now, the FTC has a 6B study that's sort of looking at kind of big platform acquisitions. And so I think they've got access to better data on these transactions than really anybody else. So it's sort of a good place for the agency to have the comparative advantage to do some research. So I think we'll see when we get to those. A lot of the acquisitions that people point to, the agencies look at pretty darn closely before they approve them. So I'm a little skeptical that you're going to see. Now, agencies get them wrong, right? Antitrust is about prediction, and Yogi Berra said prediction's hard, especially when it's about the future, and that's what these cases are about. So you have mistakes that cut both ways, right? Mergers you challenge where you shouldn't, mergers that you don't challenge but you should. But the most interesting part, I think, is there have been claims about, let's assume that we identify some mergers that fit this description, right? And we think there's a gap in the antitrust laws that needs adjusting, or at least a gap in agency performance that needs adjusting, because we find after the FTC does the 6B study, look, there are a bunch of these tech mergers where you buy the little guy and then they don't innovate and we get higher prices or less innovation or something, right? Not been shown yet, but even if it was, the real question to me when I read the House report or some of the other proposals that are around is, so now what? Do we need to adjust the antitrust laws to deal with it? I'm skeptical. There's nothing in Section 7 of the Clayton Act that says you can't get to those kinds of cases. We spent the first 20 minutes talking about the Microsoft opinion, which is based on exactly this kind of theory, right? It was not that Microsoft was doing this stuff to Netscape because Netscape competed with them today. It was that tomorrow Netscape might intermediate the operating system. And by the way, spoiler alert, but the DOJ won that case against Microsoft, and they win other cases involving nascent competition. They rarely, in fact, lose any merger cases. The number of litigated cases where the FTC or DOJ have lost, this is nascent, not nascent, brick and mortar, platform, whatever, 3 times in the last decade, they've lost a litigated challenge. It is already presumptively unlawful for any transaction above 30% market share is presumptively unlawful under existing antitrust law. It is, and the government almost still never loses merger cases. It's hard for me to look at the actual track record of what happens in those cases and find the existing law wanting. I think the complaints are much more about the political will of the agencies. The law, you could bring these cases. You can absolutely go into court and bring these cases. And you can try. And I do not doubt for a minute that as part of that FTC 6B is the authority that lets them get subpoenas out. If they find transactions that they let go through that fit this description, I think you might see retrospective merger challenges, or you might see that might give rise to a good policy proposal. Let's say what we find is there's a bunch of transactions that were really small, and so we didn't review them, and they ended up being anti-competitive. Well, you can make them all reviewable. There's things you can do. I think if that's the evidence that we see, I don't think it is yet. Doesn't mean it won't be. I think it is right that economists and the agencies are studying some of these transactions to sort of do retrospectives and sort of figure it out. I think that's to be applauded, and nobody can do those like the agencies because they've got information that the rest of us don't. Especially they can test their own predictions, right? Any of us can go test what happened in the actual market, but they can test the actual predictions. And so my own view is the existing law lets you do it. And people are studying to see if the evidence is there. And that's not looking at the evidence before you do policy is not a policy prescription that makes everyone happy, but it seems to me to be the right course.
Certainly, well, I believe one of the things that was in the report, and I think this gets to your point, that to the extent that we as a society are disappointed with the amount of antitrust enforcement that's occurred, I think what I'm hearing you say is that the question may not be whether the authorizing statutes are correctly written and need to be reformed. The question may be, are there political will reasons within the agencies? I think one of the things that was in the report is it may even be a budgetary issue. I think there's like $550 million between DOJ and FTC for enforcement budgeted versus companies that for whom $1 billion is not a huge amount of money. And so that may be, would you speak to that? Is there a David and Goliath issue to some extent when you go up against some of these big companies with not as much, obviously $550 million, if that was one case, would be a lot, but you got to spread that across antitrust enforcement for the entire economy. So do you think there might be people pulling punches because they can't commit the resources necessary to take on a Google or a Facebook or a Microsoft or a Twitter?
Three quick observations. One, I think the agency should get a bigger budget, in the FTC in particular. My FTC friends listening to this are in shock and awe because I dissented a lot when the FTC tried to do a lot of things. But the agency does. It's not just the competition stuff. It's consumer protection. It's research. This is a time, just named one area where research is really important. Research takes a lot of resources, and it is expensive to do these retrospectives correctly. It can take years. And so more resources for the agencies and the FTC in particular, because it's got that research function, I am all for, because it's got both, for both consumer protection and for competition, and to add economists in the building. Second thing I'll say is, while I am for more resources for the FTC in particular, and that's something I recommended to the House report, I don't think you've got the David and Goliath issue. That's not the resource constraint that's binding here. So when David faces Goliath in court, David wins a lot. David's fine litigating against Goliath because the law is there, and when they've got evidence that there's consumer harm, they win those cases. They don't go into court and lose merger cases too often. So it's not the in litigation David versus Goliath. I think the bigger issue is you can only sue so many people at once. And only so many lawyers. It's not that you're outgunned by Google. Every merger lawyer in the FTC ever has been outgunned by the defense. And they win a lot, all the time. The win rate is healthy. You could hold up the antitrust agency win rate against, I don't know, pick an agency where you think the world's not broken, and they're doing just fine. In my view, better that they're doing too well in the merger area. They win some cases they shouldn't in the merger area, in my view, which is an incredibly unpopular view right now, but I think it's correct. So it's not so much David and Goliath, but the resource constraints do matter. If you were the FTC and you were going to bring a bunch of novel cases where you're not just going to win on a presumption and walk out, right? You're going to go to trial a bunch. You can do 3, 4 at a time. Maybe. But if you've got 2 cases in the litigation and a tough one comes up, I promise you a serious conversation is had at the management and commission level about, can we do another one right now? Right. And so in my view, the way, I'm not a believer that the law is broken. Well, there's one way to find out. You give the agency their budget and you let them bring cases. The law says if you can show harm to competition, you win. If you think there's harm to competition in a market and you have 3 votes for that, then you should bring the case. But I think judges can handle these cases. I think the agencies litigate them well. And I believe in the process of letting these disputes be adjudicated in Article 3 courts. And it's served antitrust really well over time. And it served these agencies well over time. And I think one of the reasons that you're seeing a lot of calls for shortcuts, presumptions of illegality and bright line rules, that's sort of what that House report's all about, is don't make us litigate, put the burden of proof on the defendant, which is right. Don't let us bear the burden. Just give us presumptions and bright line rules where we win without having to fight. I think that the demand for those rules, one, it's not coming from inside the agencies. It's coming from outside the agencies. The agencies think they can win cases where there's harm to competition. Because they do. Those calls are coming, they're not coming from inside the house. And I think they're coming in part because of a view that political will in the agencies hasn't been strong enough. But changing the substantive law doesn't fix political will.
Sorry.
That's okay. Okay.
Yeah, well, real quick, I want to break in there. We've got about 15 minutes left on the schedule time. Although, unless you guys have a hard stop, I'm happy to go a little past the 3 o'clock date time. But one thing I wanted to note for our audience, there should be a button at the bottom where you could, with a Q&A. If anyone has any questions they'd like for me to ask, either the participants, if you'd like to type them in there, I'll be sure to get to them. While we're giving people an opportunity to do that, I wanted to switch topics or switch areas a little bit. And I really want to dive down, Ashley, I think a lot gets talked about the consumer welfare standard, but I've yet to hear a lot of conversation about the definition of consumer welfare. And one of the things that I read in the House report that came out of the minority, you mentioned it was not a bipartisan report. There were 2 reports issued from each side of the aisle. Was a note that there seemed to be some agreement by both sides that maybe the consumer welfare standard is, in other words, what defines consumer welfare has been defined too narrowly just around price. Do you think that's the case? Do you think there's a reason that we may need to broaden the definition of consumer welfare, or do you think it's properly calibrated as is?
I mean, that's kind of vague. I'm not sure exactly what they mean by that.
Let me give you specific examples then. So one of the things noted in the minority report is the demonetization of consumer voices on some of the platforms such as YouTube. And now we've seen just in the past few days, there's been major news publications that have been both shadow and explicitly banned from Twitter. One could argue, as from a consumer perspective, that the product of Twitter, the product of Google, and the product of Facebook, when they filter out views based on either ideological bent or maybe there's financial, reasons they're benefiting. I don't want to make it just about politics. There's plenty of reasons why a platform might shadow ban or algorithmically hinder certain views or certain news stories. Could that be defined as a harm to consumer welfare? It doesn't cost you any more or less to use Twitter when they do that, but it does harm the quality of the product in some consumers' eyes. So how would you, to give you a concrete example to work with?
I mean, I think it's first relevant asking whether or not it's even an antitrust issue to begin with. And a lot of these are, speech issues and not competition issues. It's not harming the competition to do that necessarily. And there are other existing avenues of the law to go down. But I mean, I would say about, the consumer welfare standard, even like within one school of thought, there are minor disagreements about what exactly that does entail. And, when, this kind of vague, larger statement that it's not working, I'm not sure exactly what you meant by that in this context. But no, I don't see that being necessarily very relevant.
Okay, so just to sum up, you think the consumer welfare standard as currently defined in jurisprudence is sufficient to deal with any antitrust issues that might be being examined by this report?
I mean, there's not a specific definition that it's, it's not statutory. It's not it's more of a guiding set of, several principles that I think maybe Josh would, the professor would give a better explanation of this. But, there's not one set definition to go to. So there, various things can be meant by that.
Yeah. So let me chime in here. So when United States antitrust laws shifted to making consumer welfare the exclusive goal of the antitrust laws, it did sort of two things. And there are a couple of myths that float around about how to think about the consumer welfare standard that I think obfuscate discussion around this. And so let's do some myth busting. The first is that consumer welfare is only about price. We just talked about the government winning the Microsoft case under the consumer welfare standard with a claim that had nothing to do with price, right? This happens all of the time. The government can allege harms that have to do with quality, innovation, a harm to competition that generates harm to consumers. And the harm to consumers can take lots of forms. It can take the form of quality, loss of privacy. It's got to be an impact on competition that drives that effect. But there's nothing in the consumer welfare is what economists mean by it, which is consumers are willing to pay for it. And consumers are willing to pay for, I like my iPhone because it's shiny. And I like my car because it's fast and red. There are a lot of things that aren't price. And they're captured in willingness to pay in economics. And if they're captured in willingness to pay, they're part of consumer welfare. And the cases reflect that. There are all kinds of cases that the agencies bring that are not about price or output.
I think the Microsoft case is a really great example of that. That was a zero marginal cost case, and a lot of these cases are not all predatory pricing cases.
Yeah, and so there are plenty of examples where the underlying claim is about innovation or quality. Most of the hospital cases, for example, that the FTC brings aren't really about price; they're about quality. In any event, so the consumer welfare standard isn't just about price; it is broader than that. It does require, the limiting thing is it makes antitrust about competition. Antitrust is not a hammer that we use for nails that have nothing to do with competition. And so in that history of the antitrust laws from 1890 to 1977, the reason that there was a demand in the courts and in academia, and then later within the agencies to sort of for the antitrust revolution that came out of the antitrust paradox and Robert Bork's work and the work of others who followed him, was because if you look at antitrust law between the 1890s and 1977, it wasn't just that everything was illegal that was the problem. It was that antitrust was serving six masters at the same time, and it was unclear. You could, if it could be, a hodgepodge of socioeconomic goals. Antitrust could be to protect a particular industry. Small dealers and worthy men is a phrase that's used often in the early cases. And like most things, we try to do six things at once. There are trade-offs. And antitrust laws, I don't like one of those six, and so the thing's illegal. And one of the reasons why there was overwhelming bipartisan support for the shift to the consumer welfare standard, why the big shift is not 5-4 decisions, it's Scalia and RBG together and a bunch of decisions, is because you can't read those early cases and make any sense out of them. You can find all sorts of propositions, lots of them contradictory to each other, and imagine being an Article 3 district court and trying to deal with it. The precedent says everything. And so antitrust made that shift, but there's nothing limiting in terms of you got to be able to touch and feel it with a price. What it does do is for claims that are complaints about various other socioeconomic problems that may or may not be linked to competition. Antitrust has never been it's a powerful set of remedies, but it's never been meant to be a set of remedies we apply to, grievances about things firms do that we don't like. That's, and so there are large firms that do things we don't like. Maybe they, content moderation is a big issue right now. Some firms are doing things that, they do plenty of things that conservatives don't like. They do plenty of things that liberals don't like either. But the antitrust is not a complaint suggestion box where we get to break up firms when we see stuff we don't like because the firms are large. The answer to problems with speech under the antitrust laws is and always has been more speech. It's not using the antitrust laws to stifle or put a bunch of politically appointed bureaucrats in control of in control of speech, right? Anybody who thinks that putting 3 or 4 or 5 FTC commissioners in charge of the Facebook or Twitter or Google interface, that will result in more competition rather than less, or that will fix those problems, I'd like to invite to my poker game.
Well, we've gotten 2 questions in. I want to make sure we have time for those. First, we have a question for Ashley. You mentioned the potential impact of more robust antitrust laws on startups and venture capital. Would you please expound on those concerns? With venture capital increasingly gravitating overseas, such as to Asia, are you concerned that startups will have a harder time raising capital if an exit through M&A is more difficult? I think this references what you said, that the exit is as important as the entrance. Josh, Ashley, what would you say to that question?
Yeah, I mean, you see this not just in antitrust, but of course, new business moves to friendlier regulatory environments every time. You see this too with startups like privacy law, for example. And I'm not sure exactly what some of the statistics are, in terms of where it would move. But it's not a coincidence that there's not a Google or a Facebook in Europe, for example. Looking at whether or not they can exit or enter the market, definitely impacts where venture capitalists are putting their money. So those series of business decisions that are made are, of course, affected by antitrust law.
Great. We actually got another question in here too, so we still got 2 more to deal with. The main argument we're hearing from some calling for the breakup is that there could be more innovation if we break them up. How does this square with the underlying antitrust law, and is this a legitimate argument? It's ostensibly for both of you, but since you just spoke, Josh, why don't you give your thoughts on that?
Right. So there are places in antitrust where structural remedies, breaking up firms, can be the right remedy. None of them are the types of things that are being alleged around these firms. It's sort of general grievances about firm size. Sometimes the structural remedies make the least amount of sense around the claims that have been sort of made. So, where you think that integration of complementary products is really important. So think about a search engine and I type in, pizza joint in Arlington and I get a map. The reason I got a map, because Google made a map and it's a lot better than MapQuest, for example, not to pick on anybody in particular, right? But one of the reasons they made the map was because they felt like the maps out there weren't great. So they made their own map. And the benefit of combining, I'm using that as a generic example of the benefit of combining complements, right? We want to combine complements, and sometimes we do it through internal growth and sometimes we do it through merger. But that's what a lot of what happens on these platforms is the combining of complements. Breaking up firms that are combining complements is a recipe to create market power at both levels rather than combining the complements. It's like the one place in antitrust since, Cornell in the 1800s, everybody has known it's a pretty bad idea. There aren't places for those sorts of discussions, but most of this is sort of using breakup as a proxy for there's not an economic argument about the breakup being better. Specifically, it's just sort of a generic preference for small firm size. And in some of these discussions, at least in the ones where I find the proponents of the breakup idea are being sort of the most direct and honest, they will say, well, what we're going to do is we're going to make a bunch of smaller firms. We're going to give up the consumer benefits that arise from larger firms, whether it's cheaper prices because of economies of scale, or whether it's better quality because we're integrating complements. We're going to give those up. Consumers are going to be worse off, but because we've got small firms, we're going to get something else. You're going to get more democracy. You're going to get more, less large firms controlling the political process. You're going to get some other political benefits. I think that's really the conversation that is being had. It's not really about economic claims that the breakups will make, or smaller firms in general will make consumers better off. I think that's just not true. The real claim is there's a political preference for smaller firms because they think it generates some other good. And I think the best, most direct conversation someone can have about that is, okay, well, if we were going to make consumers poorer by adopting proposals, show me what we're getting in exchange for that. Show me what the benefits are. In my own judgment, that demonstration has been lacking. And so I find most of the policy proposals lacking as well. But that's the way I see it.
Ashley, have anything to add on that one?
I just add that, in a lot of these cases, breaking up would actually make a lot of the cited problems worse. A lot of these problems are problems that are solved by resources. And you cited content moderation earlier, but, what would be worse than having, Twitter do it, having 4 Twitters does not make it any better, for example. A lot of these problems are solved by having, Google's a better search engine because it has size and it has data. That's why some of these smaller search engines or maps or whatever do not function quite as well. So, and in a lot of these cases, it is size that does benefit the consumers.
Got it. We have one last one here. Do you see the DOJ stating in the Google complaint that, quote unquote, users do not benefit from indirect network effects in an equivalent way as a way to avoid Amex? I assume they mean Ohio v. Amex. How do either of you see Amex/platform market definition playing a role in the Google case?
That's a great question. The answer is yes, absolutely. That's why that was done. That is an attempt in the complaint to get around Amex, and it's a clever attempt in the complaint to get around Amex. So yes, yes, and yes. There's no way in these cases, especially, so there's a little bit of a trade-off here, right? So you bring it as a Section 2 case for a couple of reasons. One reason you bring it as a Section 2 case is Amex was Section 1, and maybe you get away from Amex there. The logic of Amex isn't wed to Section 1 or 2, but, Amex was Section 1 case. You get a little bit of a chance to get away from Amex there. And the other reason is it looks a little bit more like the Section 2 Microsoft claims. Third reason, I think, is if you bring a Section 1 case challenging the agreement between Google and Apple, we'll start asking why Apple's not in the case. Apple, by the way, is the one saying, hey, give me $12 billion if you want on my phone. You figure out what the scarce asset is and tell me why the case is brought against Google and not Apple. And so they don't want to invite that argument. And so you put it on Google for that reason as well. I will say that whether Amex is involved or not in terms of market definition, the real spirit of Amex is look at effects on all the sides. Whether it's Section 1, Section 2, it's look at all the effects on all the sides. And so if I'm Google in a case like this, you can cite Amex or not cite Amex. When I'm Google arguing for the pro-competitive benefits arising from the search distribution agreements that they make, they pour a ton of money into Apple. They pour a ton of money into the Android ecosystem that's passed on to consumers in a bunch of different ways. They're basically subsidizing Apple's entry into the search engine market, subsidizing a cheaper price of Android phones. By making these payments for distribution. And those benefits happen in all kinds of different markets. In antitrust law, there's no prohibition in Section 2 that benefits that arise in other markets don't count. That prohibition does exist in merger law, but not in Section 2. So I don't think, the way that I think the Amex logic comes up is I don't think that there's any bar on Google or a defendant in any one of these cases bringing up and trying to demonstrate and substantiate benefits to consumers outside of merely the search market. And so I think they get to bring those up either which way. Whether they can do that persuasively, what kind of evidence, well, that's what litigation is for. But I think in the spirit of Amex that those types of benefits count. that's where you're going to see those Amex issues arise. I don't think it will be in market definition in the way that it was sort of structured in Amex, but I think that's the way that those issues come to the surface in the litigation.
I would also add, I mean, somewhat as a side, not just related to Amex, the points you're making on Section 1 versus Section 2 are really significant. It's really significant that they brought it under Section 2 and not Section 1, although Section 1 might have made more logical sense, but Section 2, they also didn't name any remedies yet. So it does kind of leave the door open for the government to perhaps propose something that would fundamentally more so alter the way the business operates. I don't know if they'll be able to get there or not, but I think they certainly left that door open.
Got it. Let me make sure we don't have any more. I think that's it. Before we adjourn, first let me thank you guys for joining and also give you both an opportunity if there's any closing remarks you've got on the subject. Josh or Ashley, is there anything you'd like to say before we adjourn?
I think that pretty much covers it. I know we're running over our time a little bit here.
Great. Well, thank you both for joining us. Thank you, audience, for attending and looking in on us. Sorry for all of the issues with tech. It sounds like we had both maybe stuff on our individual ends, and then Zoom itself seemed to be kicking us off periodically, so apologies for that. If you missed any of this, if you caught it halfway through, the video will be up on our YouTube page and our website within a few days. And again, thank you for joining us, and we look forward to having you in future events. Thank you, Ashley and Josh.
Thank you.